What happens when a global tech giant like Google faces off against a national data protection authority over how it handles your personal data?
It's a really interesting question, isn't it?
Yeah, and today we're doing a deep dive into exactly that, a recent complaint filed in Uganda against Google LLC.
Right. This isn't just, one specific case. It really gives us a fascinating look at how these data protection laws are actually being applied globally.
And what it means for us, right? How our
Hmm.
personal information is handled by these huge tech companies.
Exactly.
So our deep dive today, it's based on excerpts from the official decision document. This comes straight from Uganda's Personal Data Protection Office, the PDPO.
Yep. Complaint number 0811246683, and it involves 4 Ugandan complainants against Google LLC.
Okay, so our mission here is to unpack the core allegations, try to understand Google's defense, and really explore the PDPO's detailed reasoning.
And the implications, which could be pretty big for data privacy worldwide.
Definitely. Get ready for some crucial insights about your data rights.
Let's get into it.
So what exactly prompted these 4 individuals in Uganda to, take on a giant like Google? What were their main complaints?
Well, the complaint landed at the PDPO on November 8th, 2024. And you've got Mr. Ssekamwa Frank, Mrs. Nanny Sharon Pamela, Mr. Mumper Raymond, and Mrs. Awino Mercy.
Just regular citizens then.
Pretty much facing off against, a tech behemoth. They felt their fundamental rights were violated. So they laid out 3 main breaches they believed Google committed.
Okay, what were they?
First, they said Google, acting as a data collector, controller, and processor, failed to register with the PDPO. That's a requirement under Uganda's Data Protection and Privacy Act and its regulation.
Right, registration. Point 1.
Point 2. They claimed Google unlawfully transferred their personal data outside Uganda without meeting the necessary legal conditions set out in the act.
Uh-huh. Cross-border data flows.
Ugh.
Always a tricky one.
Always. And third, they argued that these actions, well, they infringed their data protection and privacy rights and caused them distress. So they were looking for remedies, maybe even compensation.
Okay, serious allegations. Now, Google, they eventually responded, but it sounds like they took their time.
They did. That's actually a key part of the procedural story here. The PDPO told Google to respond by March 12th, 2025.
Yeah.
Google missed it, didn't ask for an extension until early July 2025, just for 2 weeks, and finally got their full response in on July 10th.
So when they did respond, how did they counter these points?
They made 4 main arguments in their defense. First, they acknowledged processing Ugandan user data,
Yeah.
but they argued their corporate entities are separate.
The classic corporate veil argument.
Sort of.
Yeah.
And they claimed no registration duty existed unless the PDPO issued a specific public notice, a gazette notice, under a particular regulation, Regulation 15.2.
Okay, what else?
Second, Google basically said its global privacy policy is good enough, that it safeguards data everywhere and meets accountability standards.
Kind of a one-size-fits-all approach.
You could say that. Third, they argued that the rules about cross-border data transfers, Section 19 of the Act and Regulation 30, only apply to controllers or processors physically located or domiciled in Uganda.
And they claim Google LLC isn't.
Exactly. They argued Google LLC has no such presence. And finally, they asked the PDPO to just dismiss the complaint altogether.
On what grounds?
They claimed the PDPO doesn't actually have the legal power to award damages or order data localization. They said if the complainants wanted that, they'd have to go to court.
Wow, okay, so quite a comprehensive pushback from Google. The PDPO then had to sift through all this. They identified 5 key issues.
That's right. 5 core questions they needed to answer.
Let's start with the absolute basic one. In Uganda's eyes, legally speaking, what is Google? A data controller, collector, processor. Does it even fit?
Yeah, this was foundational. The complainants argued Google obviously collects loads of personal data names, nationality, email, age, birth dates, online IDs, browsing history, location, you name it.
Standard stuff for their services.
Right. And critically, they said Google decides how and why this data is processed. That, they argued, makes Google a data controller and a collector.
And Google's take.
Well, Google admitted providing services in Uganda, and they admitted their privacy policy details how they collect data for things like analytics, personalization, security, communication.
So they kind of admitted the what's and why.
Pretty much. So the PDPO looked at the Act's definitions. A data controller determines the purpose and manner of processing. A data collector just collects the data.
Makes sense.
And based on those definitions and Google's own acknowledgments, the PDPO conclude Yeah, Google LLC clearly fits the bill as both a data controller and a data collector under Ugandan law.
Interesting, they specified not a processor here.
Right. They explicitly said Google wasn't deemed a data processor in this context, probably because there was no sign they were just processing data strictly on behalf of someone else. They were determining the purpose themselves.
Got it. So Google IS, a controller and collector. That leads straight to the next big issue.
Yeah.
Registration. Was their non-registration a violation?
It seems like it should be straightforward, doesn't it?
You'd think.
The complainants pointed out, hey, Google LLC isn't on the PDPO's public register. Google didn't deny they weren't registered.
So what was their argument then?
They got a bit technical. They said, okay, Regulation 15.1 requires registration, but it's subject to Regulation 15.2, which allows the PDPO to exempt certain categories by publishing a notice in the official gazette.
And since no notice exempting Google was published,
Google argued that the main registration requirement was therefore, quote, inoperative. Kind of a legal limbo argument.
that's creative. How did the PDPO respond to that?
This is where it gets really interesting legally, and it's a big takeaway. The PDPO said, nope, the general rule, the duty to register under Section 29 and Reg 15.1 remains fully in effect unless and until a specific exemption is officially gazetted.
So the default is register.
Exactly. They leaned on a legal principle from a Ugandan Supreme Court case, actually. It basically says the burden of proving you qualify for an exemption lies squarely on the party claiming it, in this case, Google.
Yeah.
And just because the PDPO has the administrative power to grant exemptions but hasn't exercised it for a specific category yet, that doesn't just suspend a company's existing legal duty.
Makes sense. You can't assume you're exempt.
Precisely. So the PDPO's conclusion was clear. Google's failure to register is a violation of the Act and regulations. No ifs, ands, or buts.
That's a pretty strong stance. Okay, issue 3. This one feels huge for any global company. Can Uganda really regulate data transfers happening outside its physical borders?
Yeah, this is a global flashpoint, absolutely. The complainants argued Google ships their data outside Uganda without proper approval, risking misuse.
And Google's counter was?
Their argument was that the rules on cross-border transfers, Section 19 and Regulation 30, only bite if the company is domiciled or physically present in Uganda, which, they insisted, Google LLC is not.
Right, we're not physically there argument.
Exactly. But the PDPO had a very direct answer to this. They pointed straight to Section 1 of the Act itself.
What does it say?
It explicitly states the Act has extraterritorial application. It applies to, and I quote, a person, institution, or public body outside Uganda who collects, processes, holds, or uses personal data relating to Ugandan citizens.
Wow. Okay, so if you handle Ugandan citizens' data, the law reaches you. Period.
That's the message. The PDPO stressed that you have to read the Act and its regulations together harmoniously. It's a standard principle of interpretation.
So the location of the servers doesn't matter as much as the location of the data subjects.
It seems that way, yes. But there was another crucial piece here. The PDPO didn't just rely on the text of the law.
Oh, what else?
They pointed out something very practical. Google LLC is actually a registered taxpayer in Uganda. They're listed by the Uganda Revenue Authority as an active digital business paying VAT and digital services tax.
Ah, so they do have a tangible connection.
Precisely. The PDPO called this a commercial presence and revenue nexus, and they said this basically demolishes Google's argument that they're somehow beyond Uganda's regulatory reach if you're making money there, benefiting from the economy.
You're subject to the rules there.
That's the logic. And the PDPO also clarified something about approval for transfers. The law doesn't mean Google needs advance permission for every single transfer.
Okay, what does it mean then?
It means Google needs to have a system. They need proper records showing the legal basis for the transfers, the safeguards they have in place, and they need to be accountable. Those records should be available for the PDPO to inspect.
And Google hadn't provided that.
Apparently not. The PDPO stated Google failed to provide such records or demonstrate compliance. So the conclusion was another violation breach of Section 19 and Regulation 30 on cross-border transfers.
That commercial presence point feels like a really significant interpretation for global tech.
I think so too. It suggests that just because you don't have a physical office doesn't mean you're off the hook if you're actively doing business and handling citizen data.
Okay, moving beyond the legal points. What about the people involved, the complainants? Was there evidence of actual harm or distress?
This was issue 4. The complainants argued that Google's failures, especially not registering, put them at risk. And crucially, without a registered data protection officer or DPO for Uganda.
They had no one to contact.
Exactly. They specifically mentioned sending an email to Google's chief compliance officer back in October 2024 about their concerns.
Oh.
No reply. It went unanswered. They argued this lack of response, this uncertainty, caused them real anxiety and distress.
What did Google say to that?
Google denied it.
Yeah.
They pointed to their global privacy controls and said there was no specific evidence that complainants were actually harmed.
But the PDPO saw it differently.
Yes. They determined that the registration requirement isn't just red tape, it's fundamental for accountability. It ensures people know who to contact within a company about their data rights.
So Google's failure to register directly led to the problem.
That's what the PDPO found. It meant the complainants had, quote, no means of knowing or contacting the designated data protection officer for Uganda. And that unanswered email wasn't just ignored, it directly caused genuine distress.
Only genuine.
Because they were left hanging. No recourse, no answers, no assurance about their personal data. The PDPO said this distress wasn't just theoretical or speculative, it was a real consequence of Google's non-compliance.
Interesting. It highlights that the lack of an accountability channel itself can be harmful.
Precisely. It's not just about data breaches, it's about having your concerns heard and addressed.
Okay, so after analyzing all these issues, where did the PDPO land? What were the final declarations and, crucially, the orders for Google?
Right, the wrap-up. The PDPO made 3 key declarations, basically summing up their findings. First, Google LLC is a data controller and collector under the Act, no doubt.
Check.
Second, Google's failure to register is a violation of the Act and regulations. And third, Google's transfer of Ugandan citizens' personal data outside Uganda without showing adequate safeguards or accountability is also a breach.
Okay, 3 clear violations declared. What did they order Google to do?
Based on those declarations, they issued some specific time-bound orders. Number 1, Google LLC must register with the PDPO within 30 days of the decision.
40 days. That's pretty quick.
It is, and that registration needs to include contact details for their designated data protection officer for Uganda.
So providing that point of contact.
Exactly. Order number 2. Also within 30 days, Google must submit documentary evidence showing its compliance framework for cross-border data transfers. Basically, prove you have the safeguards you're supposed to have.
Show your work, essentially.
Pretty much. Now, interestingly, the PDPO did not order data localization at this point. They didn't say Google has to keep data in Uganda. But they did remind Google they need to comply with Ugandan law for all transfers wherever they go.
Okay. What about compensation for the complainants?
Good question. The PDPO explicitly stated it cannot award compensation or interest. That's outside its powers, according to Section 33 of the Act.
So if the complainants want damages?
They have to pursue that separately in a court. The PDPO can only handle the regulatory compliance side, it seems.
Got it. Any other orders?
Just that the PDPO reserved the right to make further orders if needed?
And what happens if Google doesn't comply with these orders within 30 days?
Well, that's serious. Failure to comply is an offense under Regulation 48. It can attract a daily fine calculated using something called currency points or even imprisonment for up to 6 months, or potentially both.
So there are teeth to these orders.
Definitely seems so. And of course, there's an appeal process. Either party, if they disagree with the decision, can appeal to the Minister of ICT and National Guidance within 30 days.
Okay. And this decision was dated?
July 18th, 2025, signed by Baker Barakuja, the acting National Personal Data Protection Director.
Right. This whole deep dive into Google versus Uganda, it really does spotlight this growing global trend, doesn't it? You have national data authorities stepping up, asserting their power over massive global tech companies.
Absolutely. It's happening more and more.
And it just raises that huge question. As data flies across borders so easily, how are these massive companies going to handle this complex patchwork of different national privacy laws?
It's a massive challenge for them, no doubt, navigating dozens, maybe hundreds of different regulatory regimes.
And what does it all mean for the future of our data privacy for accountability worldwide? What really stands out to you from this specific case? And maybe for you listening, what further questions does this whole situation spark about your own digital footprint and who controls it?
Lots to think about there. That extraterritorial reach and the commercial presence argument are definitely key takeaways for me.